This case might look like a routine traffic stop, but very quickly, it turns into a legal battle over perception and proof. A deputy claims he identified illegal window tint in complete darkness at highway speed. But the defense is ready to challenge that claim from every angle. This isn't just about a traffic violation. It's about whether instinct alone can justify stopping someone. So the real question is, was this a trained observation or just a risky guess?
Yes.
And were you able to see into Miss Cowan's vehicle?
No.
Now, I know we had gone over this before, so when she went in front of you, what, if anything, can you describe to us, did the interior look like?
I can't tell you what the interior looked like. It was too dark.
And if someone has correct window tint, are you able to see how many people are in the vehicle?
Yes.
Are you able to kind of tell what the interior of the vehicle looks like?
Somewhat, yes.
All right. Now, if someone's a lay person, is their experience different than what your experience would be as an officer and being able to tell as a vehicle passes if it's too dark of a window tint?
You said if somebody was a what person? I'm sorry.
A lay person versus someone like you with experience.
Correct.
And have you been using this technique for a while?
Yes.
And have you become more experienced at using it on a daily basis?
Yes.
And when you stopped this car, did you eventually test the window tint?
Yes.
What was the window tint reading of the vehicle when you were able to test it?
I'd have to refer to my report. I don't have it in front of me. I'd have to pull it up real quick if that's okay with the court.
Did you prepare a report to reflect your recollection?
I did.
Did you have an independent recollection of it when you prepared your report?
Yes.
And are you needing it to just refresh that recollection?
Yes.
Your Honor, may he refer to his report?
Yes.
I'm sorry, this was in the old system, Jill. I'm trying to get it all pulled up.
Okay.
It was 11% window tint,
What is the legal percent in the state of Kansas?
35%.
And now, Deputy, when you fill out your probable cause affidavit, because I know this question was asked at the prior hearing on the same exact motion to suppress, is the probable cause affidavit designed to be an end-all be-all of everything you do on a traffic stop?
No.
What is it only for your probable cause bare minimum?
Just for the arrest.
All right. Do you explain every time you go through a case, all of your experience or how you use specific testing?
No.
And so, is there anywhere in your report you explain how you use your experience and this technique of checking windows?
Not that I believe.
I will pass this witness to the defense.
Cross-examination, Mr. De Hoyos.
Judge, thank you, sir. Deputy Fisher, I want to make sure I understand the way in which you determined the windows were too dark. How long did you have to observe the vehicle that you pull over?
I don't know an approximate time frame. I mean, she was driving by at highway speeds.
Okay, and that highway, that's US 54 or 54 400, is that what that is?
400.
Forgive me, 400. Is 70 there? 75?
65.
65, okay. Middle of the night, right?
Correct.
And you say that the technique you employed was you flash your high beams to see if you could see through the windows, is that right?
I don't flash them, I sit with them on.
Okay. So you sit with them on and help me understand what happens after that.
As the vehicle drives by, I make my observations.
Okay. And is there, I mean, is this a lawfully approved technique? I mean, is there a sheriff's or a county association or any kind of police association that approves of this technique?
Mm, Not that I know of. I mean, it's reasonable suspicion. She drove by, saw that the window tint appeared to be too dark, so I had reasonable suspicion to believe that the window tint was too dark, so I initiated the traffic stop.
So hear me out, Deputy Fisher. I appreciate that. When it comes to the lawful definition of reasonable suspicion,
At this point, the defense is starting to apply pressure. The officer admits there's no official study or standardized method behind this technique, just experience. Now that's important because in court, experience alone isn't always enough. The law requires reasonable suspicion, not just routine practice. So think about it. If there's no scientific backing, can this method really be considered reliable enough to stop someone?
all that. I'm not worried about that. I'm trying to understand the facts. And the fact is, you use a technique that has not been supported by any lawful community or law community that you're aware of.
No, we
Okay.
all use it.
Okay. Have you ever seen a study on the error rates of something like that between the difference of being able to identify too dark and not too dark?
No.
Do you think that difference would allow you to understand negligible difference, like the difference between 33% and 37% dark?
If I took a class, it might.
But as you stand there, your experience is not allow you to decipher differences like that in a passing glance.
You said what?
As it stands right now, you don't have the experience to be able to say that in a passing glance what percent the window tint is.
I can't tell an exact percentage, no. And I don't think anybody would be able to tell an exact percentage, but I know that if a vehicle is driving by and I can't see into the vehicle, it's reasonable to believe that it is too dark.
Okay, so if somebody drove past you while they're holding a blanket against the window, does that mean their window tint is too dark?
No,
Okay, but that would still create the same effect that you not being able to see through the windows and then pulling them over because the window tint is too dark, even though that wouldn't be true, right?
I would disagree with that.
Okay, which part?
Well, if the window tint was not too dark and they drove by and they were holding a blanket up, I would be able to see that they were holding something up. As she drove by, I wasn't able to see her or any other person in the vehicle, indicating that the window tint itself was too dark.
Okay. And are there any outside circumstances that can affect your judgment as to the lightness or darkness of the window tints as they fly by at 65 miles an hour?
As in,
Oh, I don't. In a storm, would you just make the same call? Would you make the same pullover and same arrest?
I mean, it could alter some, I guess, but no, not really.
What if it's an all black background that they go against?
If it's an all black background, there was no other lighting where we were, so it was an all black. We were
Okay.
sitting stationary in the middle of the county, and the only high beam headlight or the only lighting that was shining on the car was my high beam headlights.
Yeah. No, I guess what I'm asking is if on the other side of that car was all black, that you don't think that would affect the way you reviewed that car? It wouldn't make things look darker than they were?
I'm not understanding your question. I don't see what an all black backing would be on the other side of a vehicle.
I'm just trying to see if that makes a difference. If the background was all black versus nothing else back there, would that make a difference about the transparency of those windows?
I'm gonna say no.
Okay. So at the time in which you observed the defendant's vehicle, was it by itself or was there any other vehicle within its proximity?
It was by itself.
Okay. So if the video of you observing that, I think it was a Chevy Sonic, demonstrates that it was right next to and alongside an 18-wheeler that was all black and that you observed it with the all black background, that would not be consistent with your memory and the way you would do this technique. Is that correct?
I mean, from what I can recall, like I said, I haven't been through the video, I haven't been through the report. From what I can recall, what I saw was her. I wasn't paying attention to any other vehicle. And it was the front passenger side window that I was paying attention to. She was closest to me. We were in a 4-lane highway. She was heading eastbound. She was the closest vehicle to me. So I was looking at that window specifically.
Okay. Well, I appreciate that. Jill, I have a body or a dash cam video. This is 234A. that I want to admit, but I've never tried to admit a video on Zoom Court.
You have to log in your laptop generally separate from whatever device you're on for Zoom so that there's you and the separate video. And then you have to admit the laptop separate and then pull up your video and play it. And there's a share screen request that has to be on by the court's AA.
I wish I had known all of that before I got in here today. Okay. Well, Judge, I could move to admit to that video so you could see it, watch it on your own time. I mean, it's the video of him, what he would have seen as she went by and the background behind it. And you can suspend ruling until such time as you've seen that video yourself. I think the video speaks for itself.
Well, let's do it. Okay.
Now we see a shift toward evidence as the courtroom prepares to review dashcam footage. This is where things can either support the officer or completely challenge his memory. Video evidence often becomes the most objective piece in cases like this. So the big question is, will the footage confirm what the officer believed he saw or expose inconsistencies in his testimony?
These are misdemeanor charges, correct?
No, sir. That's what gives rise to the ability to have the hearing, is because the misdemeanor DUI becomes a felony DUI.
Thank you. Thank you. Okay. Well, figure out so the court can view what is in question, and we can take a few minutes to do all that. Okay, court's in recess off the record, and I'll let everyone stumble and fumble around as best you're able to get that accomplished so the court can view what Deputy Fisher viewed.
May we turn the cameras off while in recess? Okay.
You can turn off your video.
Alan, I think you'll have to admit my laptop, please.
Just did.
And is share screen on? Okay.
I'm checking.
Are you ready?
Yeah, it sounds like we're going to admit through Jill's computer, the same video.
Can you hear me okay?
Yeah, I can hear you on the new laptop you just admitted. We've got video of you in the other one.
Yeah. Because I have to switch over sound for the computer.
Yeah, sorry about this, guys.
When Judge is back, I'll be ready.
And then Jill, would you stipulate the foundation on this one?
Oh, yeah, it's our video.
We're back on the record. Record may reflect presence of the defendant along with respective counsel. Please proceed, Mr. De Hoyos.
So, Your Honor, I'm going to move to admit Defendant's Exhibit A. This is the dash cam video from Officer Fisher's vehicle that demonstrates what he would have seen as the vehicle the defendant was driving passed him by at 65 miles an hour on US 400.
Any objection by the state? Miss Gillette.
No, Your Honor.
The exhibit is admitted into evidence and the court will view the same.
Sharing's not turned on.
It should be good now.
Can you see it okay, Judge?
Yes.
I watched them move me and you went down into my field. That's the sky so when I think of brightness within, I like the dark and into my love. How do you do? Really feel my baby's proud and I lost in there'll be much more that we'll know in that to my world. Someday we should all stop, wake up with bells of love behind. Trouble bounce like a lemon drop. I will let you that's where
Judge, if I may resume cross-examination.
Yes, please resume cross-examination of the Deputy Fisher.
Just real quick here, Deputy, that's a true and accurate copy of the video that would have been observed from your dash cam that night. Is that right?
Correct.
Okay. And there was at least another vehicle on the roadway, that being the semi that was behind the defendant's vehicle. Is that right?
Yes.
Okay. And do you agree that that's a little different than the testimony that there was another vehicle with it? There was another vehicle with it, right?
Yes. Yes.
Okay. That's all I got for you, Deputy. I appreciate that.
Any redirect, Ms. Gillette?
Yes, Your Honor. Now, Deputy, he's asked you lots of questions about what was behind the vehicle, but you said you were concentrated on the front window and inside. Does it matter what's behind the vehicle?
No.
And your testimony was that you're focused on the window. Are you focused on being able to see what's in the vehicle versus behind the vehicle?
Yes.
Now, I kind of alluded to this before. I get to spend a lot more time with deputies and talk to them. I've even done ride-alongs. Based on your experience, can you tell when a vehicle is approaching if it's faster or slower than what should be normally the speed of the vehicle?
Yes.
How can you tell?
Based on my training and experience, I've been doing this for long enough to know that the way the vehicle is oncoming towards me, I can kind of adjust the speed in my head and kind of see how fast it's going, and then I affirm that with my radar.
Now, is it the same when you're doing these window tints?
Yes.
But you need radar to tell what the exact speed is.
Correct.
So if a vehicle is approaching you from the front, do you change your radar to your front?
Yes.
If the vehicle is approaching from the back, what do you do if it's approaching from the back?
Switch my radar to the rear.
And you said all of us do this test. What do you mean by all of us?
Like deputies and officers in general, we use the same practices.
So to your knowledge, are there other deputies using the same practice of using the high beams to see into the vehicle to see window tint darkness?
I would assume so, yes.
Do you do it on a frequent basis?
I do.
How often would you say you do this?
Every night that I work.
Judge, I'm going to object to the relevance of these questions. If the strategy is inappropriate from the beginning, it doesn't matter if he does it 1,000 times a day.
Now,
Objection sustained.
I'm getting to my point, Judge, because experience, based on the experience and totality of the circumstances, is what he needs for only reasonable suspicion. He doesn't have to have probable cause. And he's already said he could reasonably infer that her window tint was too dark. And we're getting to his experience here. Deputy, are you provided with a tool to measure window tint?
I am.
Are you able to use that while a vehicle is in motion?
I am not.
So if you have a reasonable inference that the window tint is too dark, do you effectuate a traffic stop?
I do.
What happens when you effectuate a traffic stop with a reasonable inference that the window's too dark?
After explaining the reason for my stop, I test the window tint.
Can you test it at night?
Yes.
Can you test it during the day?
Yes.
If someone's window tint is legal, what do?
I let them on their way.
If the window tint is too dark, then what do?
I take further action, whether that's issuing them a warning or a citation.
Now, in this case, based on your experience, did you have a reasonable inference that this window tint was too dark?
Yes.
Once you stopped the vehicle, did you conduct the window tint test?
Objection to relevance.
It's relevant if he confirmed that it was too dark.
By that time, we're saying it's already illegal, so it doesn't matter.
Objection sustained.
Now, does any officer or anyone have a test they can do on windows prior to stopping the vehicle if they have a suspicion?
Not that I know of.
Objection or relevance?
Objection sustained.
Judge, it's relevant because if there is
Objection
no,
sustained.
is there any device that you've been provided that can test a window before you have the reasonable suspicion to stop it based on your experience?
I'm gonna object to that as for a legal conclusion.
No, it's asking if he has a device.
Well, the request of before you, that's the
Objection
problem.
overruled.
Do you have a device that can test window tint before the stop?
No.
Do you have to stop the vehicle to test the window?
Yes.
In this case, based on the totality of the circumstances, the technique in which you were trained and your experience, did you have a reasonable suspicion her window was too dark?
I did.
Now, besides the window tint being too dark, was there anything else that drew your attention to this vehicle?
Here, the officer doubles down on his experience, explaining how he judges speed and applies similar logic to window tint. But there's a key difference. Speed can be verified with radar, while tint cannot be measured until after the stop. That creates a legal gap. So now the issue becomes clear. Can a visual guess, without tools, really meet the standard of reasonable suspicion?
The driver herself.
Okay. Now, I'm gonna ask.
Wait a minute. The court makes inquiry. It's the court's understanding that the deputy is now testifying that the defendant herself he could see the defendant herself. Is that what's being testified to
This
with
is
this too dark a tint at night windshields?
Judge, my recollection of what Miss Jill Gillette was asking was after the vehicle was stopped.
Okay, court stands corrected. Thank you.
Now, once you stopped this vehicle, was there something else that drew your attention onto it more?
The window was rolled partially down.
And did you run the tag on the vehicle?
I did.
Were there any issues with the registered owner?
She had a no bond warrant out of Butler County.
Now, but your initial stop was based on the window tint.
Correct.
Okay. And which window was rolled partially down?
I'm gonna object to relevance.
It's irrelevant because if the driver's side window was rolled partially down or the passenger side window was rolled partially down, if he can't tell that the other window was rolled down until he stops, that's further evidence that he couldn't see into the vehicle because he couldn't see her and he couldn't see into the vehicle.
I'm confused. Are you saying that the window
I'm
was partially?
confused also. What about the rolling down of a window makes it relevant as to the tint percentage darkness to the windows?
I'll withdraw the question. So deputy, when she drove by, could you clearly see the driver?
No.
Could you see if there was a passenger?
No.
Could you see anything into the vehicle?
No.
Is that normal?
No.
I'll pass the witness.
And Mr. De Hoyos?
The
Recross?
only reason you, sorry, Judge, the only reason you stopped that vehicle is because the window tint appeared too dark as it passed you at night going 65 miles an hour. Is that right?
Correct.
Okay. You said that based upon your training, you determined it to be too dark. What is the training you've had in identifying window tint being too dark?
Just at work.
What kind of training? Like a national training like you did for your CLEs and for your law enforcement training, or was this something different?
Just my regular field training.
Okay, so in field training, they teach you how to use your eyes to determine tint values in a vehicle.
Correct.
So Kansas Law Enforcement Training Center has classes on how to identify.
Mr. DeHoya, I just said my field training. That was not my academy training. My
Okay, so
field training.
okay. And the field training, who provided you the field training on how to identify how dark windows are?
I was with numerous deputies.
Okay. And are they using a national program, something that's been federally approved or even
I
approved by any
don't
law
know.
enforcement?
I
Have
don't
you
know.
ever seen any literature on any of those things?
I've already asked and answered no.
Okay. And there's no studies you've seen about how observations could be changed by the direction of travel, the way the light hits anything behind it, nothing like that.
No.
Okay. Yeah, I don't have any further questions for this witness.
Any objection to the witness, Deputy Fisher, being excused from the proceedings? Ms. Gillette
No, Your Honor.
and Mr. De Hoyos.
No, that's fine, Your Honor.
And the Deputy Fisher, you're free to stay or go if you wish. Have a
Real
good day.
quick, Judge, Jill, are we still on the next case with the Williams with Judge Hart?
Yes, you'll have to stay.
This moment gets interesting as new details come in about what the officer noticed after the stop. But remember, the court isn't focused on what happened after. It's focused on the exact moment the decision to stop was made. Anything discovered later doesn't justify the initial action. So ask yourself, should later discoveries
Okay.
influence
I'm sorry,
whether the
Judge.
stop itself was legal?
Yes,
What-
Belen, could you
what
say
ca-
again?
The Williams case, which case is it?
Alexander Levon Williams was also set for a motion today.
It was moved out to December the 18th. That's what I have.
Motion on the Williams case pursuant to my AA Belen has been rescheduled to December 18, 2025. So with that being said, any reason why the Deputy Fisher may not be excused?
No,
Ms. Gillette,
nope, he can be excused, Your Honor.
Deputy Fisher, you're free to go or stay as you wish.
Okay,
Thank you,
Judge,
Deputy.
also, Deputy Chandler and Deputy Postier were here for the Williams case too out of Wilson County.
I believe they can be excused.
In regards to the Williams case that I don't have on docket at this time, I've been advised by Belen, my administrative assistant, that has already been rescheduled to December 18, 2025. I don't know what time. Belen, by chance, would you know if it's in the morning or afternoon docket?
Sorry, I was on mute. It's in the morning at 9 o'clock.
Thank you, Belen. It's on the morning of Thursday, December 18, 2025 on the 9 a.m. docket. All right. Further evidence to present? Ms. Gillette.
The state will rest, Your Honor.
And evidence to present, Mr. De Hoyos.
Yeah, between the deputy testifying and the exhibit, that's what we have.
Thank you. Council request any argument in regards to the motion.
Please, Your
Ms.
Honor.
Gillette,
Yes,
please proceed.
Your Honor, in a traffic case and a traffic stop, officers do not have to have probable cause beyond a reasonable doubt. They have to have a reasonable inference. An inference is much, much, much lower. An inference can be being in the vicinity of a burglary and matching a description of the burglar. An inference can be that they were seen leaving the building of the place where the crime is happening. They don't have to have the complete testing of an exact specific number. An officer is allowed to use their training and experience in the totality of the circumstances. As Deputy Fisher testified, it doesn't matter what's behind the car. He is focused on the front window of the vehicle. Officers have experience we don't have. I've ridden with several officers and they'll be like, that vehicle's going too fast, flip their radar, be able to catch the exact speed. But you can't do that with window tint. It's based on the training and experience of the officer. Deputy Fisher has said all of the officers he has rode with use this same technique of turning on your high beams, that they use that experience to know whether or not the window tint is too dark by being able to view the person inside, whether or not you can see a passenger, whether or not you can see the seats, whether or not you can see who the driver is. And when you can't, the window tint is too dark. He has done this countless times. He says he uses it almost every single night. He's able to describe in detail how that is utilized to look into a car. Now, I also happen to know that when I, as a layperson, am driving behind a vehicle, it takes me a minute to be able to get a license plate. They're able to do it quickly, and I can't do it as quick as they do based on their training and experience. It amazes me how quickly they can grab a license plate number or a partial plate number that we can't grab, and it takes us more time. Now, I notice license plate numbers more just because of what I do for a living, and because I've gone on ride-alongs and tried, and because I try every once in a while to see if I can do it as good as some of the officers in my jurisdictions have. And back when I was a defense attorney, can it be done? And I have tried to practice that. But the normal person with a normal eye doesn't know the same thing an experienced officer does. The Supreme Court has told us time and time again in several cases, they don't need probable cause. They need a reasonable suspicion. That is a Terry stop. A traffic stop is a Terry stop. Reasonable suspicion. Does not have to be probable cause. Doesn't have to be, I know that exact number beyond a reasonable doubt. It doesn't say that it has to be a specific number, because there's not a device that can test window tint until you stop the car.
Now both sides are building their arguments. The prosecution leans heavily on officer experience, arguing that trained judgment is enough. But the defense is pushing back, calling it nothing more than a guess without scientific support. This is where the case really becomes a battle of logic, experience versus evidence. So which side do you find more convincing at this stage?
It's a minute that they stop somebody, they test the window. If it's good, they get to send them on. If something else is wrong, they can have them for a further detention for more things, or if they need to issue a warning or a citation. This is very, very common with KHP, deputies, and local police. In this case, it's a deputy. Our troopers can't tell you an exact number, but I can tell you they write a ton of window tint tickets in my jurisdictions and others. I have two that write a lot of window tint tickets. They can't give you a specific number either when they are traveling down the road, but they sure can tell at night and during the day that the window tint is too dark based on how the lights pass through the windows and through the vehicle as to whether or not they can see the person that is inside the vehicle. This is also true during the day because there are so many vehicles you can't see into because of limousine tint or darker tints that block the view. It causes an officer safety problem. It causes a safety problem across the nation. And so that is why Kansas has this law. Miss Cowan, upon being stopped, was discovered to have an active warrant because she's the registered owner of her vehicle. That would necessitate further detention past just a window tint test. The window tint was tested, and Officer Deputy Fisher was absolutely correct. The window tint was dark. The window tint ended up having a visibility that was below 35%. Her window tint tested, as Deputy Fisher testified, at 11%, 24 percentage points below what is allowable under the law. And clearly, Deputy Fisher was absolutely right in being able to tell that the window tint was too dark under his totality of the circumstances, his experience, and his training under the law.
Argument for the defense, Mr. De Hoyos.
So, Your Honor, the reason I was not prepared to play that video was because I didn't expect the officer's testimony to be different from the facts shown in the video. Specifically, there were other vehicles on the road. There were vehicles in close proximity. And we don't have any kind of science studies or anything else supporting the idea that this is an unreasonable association. I think what this is akin to is bite mark evidence, which was outruled in the 70s and 80s. At the end of the day, Judge, I mean, this is a hunch, a guess, not a truth. The difference between some of the examples Ms. Gillette uses, wherein somebody leaving a place in which there was a robbery, is, yeah, there was a crime there. I mean, that's the difference. By that point, there was a crime. There was a known crime, right? This is, let's go see if that's too dark and pray we're right. And the idea that we do this all the time is not a defense. No, there is no science supporting this. There is no study supporting this. There's no national training or even localized training on something like this. This is akin to something you learn on the job without having any kind of scientific support to demonstrate. Now, Judge, it may be perfectly reasonable to say that law enforcement officers are allowed to make observations with their eyes to determine concerns in courses of conduct. But Judge, this is a used tool every single time and time again, without any kind of studies to show that it's accurate, studies to show that it's amenable to these situations. We don't have any kind of evidence or science describing how that vehicle being behind it changes that reflect. And what if that vehicle is reflected? What if it's matte surface? We don't know, because there's no science that supports the idea that this is reasonable to go about this way. Now, being right at the end of the day, that doesn't change whether or not the stop was initiated lawfully and legally. And so when we take this case in front of you, just this case, and we isolate it to its bare bones facts, what we have is an officer says he pulled over the vehicle because the window tint was too dark. He had to make that judgment in less than a split second as the vehicle traveled 65 miles an hour in front of him at a time and place where he cannot properly recall whether that vehicle was alone or with other vehicles, whether or not any of those other vehicles on the road would have affected his ability to see the vehicle, see inside of it, and to what difference those makes, right? So here's my point, Judge. Under the circumstances of this case, I don't think it's reasonably appropriate to believe that we can conclude there was reasonable inference based upon window tint. If the officer had waited to initiate the stop until after he read the license plate and came back with a warrant, I might not have an argument here. But if the idea is we can judge anybody's window tint at night by the flash of a second, and that's reason to pull them over, well, then none of us, it doesn't really matter. Your windows are dark at night. How can we tell the difference between window tint, just the circumstances of night, or if I'm holding something up, that's not illegal either. I mean, I guess my point here is I want more than a hunch to pull people over, and this doesn't beat that.
Thank you, Mr. De Hoyos. Court has had an opportunity to view the exhibit as presented today. The court has had an opportunity to listen to the testimony of the Deputy Fisher. Subsequently, the court finds the incident occurred well after sunset. There was no moonlight. There were no street lights, and there were other vehicles on the subject highway. The court finds a factual basis has been established. So this court determines the Deputy Fisher could not establish a reasonable inference.
The arguments are now in full swing, and both sides are clearly drawing the line. One says this is standard police practice. The other says it's unreliable and unsupported. This is exactly where judges have to step in and decide what meets the legal threshold. Because if this kind of stop is allowed, it could set a powerful precedent for future cases.
Or suspicion that the window tint exceeded the 35% darkness allowable by law. Therefore, the court does grant the defendant's motion to suppress.
Your Honor, the state asked the court to reconsider because you're ignoring the officer's training and experience that allows him in the totality of the circumstances and utilizing methodologies that are used commonly in law enforcement. Common methodologies are recognized. So we would ask the court to reconsider and deny this motion to suppress, the same as Judge Webster did, based on the totality of the circumstances and the training and experience of law enforcement officers, because they have a lot more experience out there in recognizing these things in split seconds than the normal layperson, which has been routinely recognized by the Supreme Court and the appellate courts, and we'd ask the court to reconsider.
As District Judge of Division II of the 13th Judicial District, the court overrules the state's motion to reconsider.
The state requests a stay on dismissal for a notice of appeal.
Any objection, Mr. De Hoyos?
No, I believe the state is entitled to an interlocutory appeal under the circumstances.
And the court grants the stay pursuant to the motion of the state herein. And I trust that once the appellate courts deal with the interlocutory appeal and provide the ruling back to this court, that council will give notice to this division for purposes of rescheduling any matters that need to go forward at that point in time. So the court's leaving it up, and I'll leave it up to the state, where they are the appealing party, to place this back before the court after interlocutory appeal ruling by the Kansas Court of Appeals. Anything further to come before the court, Ms. Gillette
Nothing further from the state.
and Mr. De Hoyos?
No, thank you, Your Honor. Thank you, Deputy Fisher. Thank you, everybody, for being here.
There being nothing further to come before the court, court is in recess. Now, Ms. Cowan, you need to stay in contact and communication with your counsel in regards to the status of the case and when you need to come back, if you do need to come back before the court after ruling by the Kansas Court of Appeals on the interlocutory motion of the state that Ms. Gillette has advised the state will be filing of the court's ruling today.
Okay.
Everyone, have a good day.
Thank you, Judge.
you.
Thank you, Jill. Thank you, Ms. Cowan. Thank you, Ms. Wells.
Should I just call you? Oh, he already logged off.
And here's the final ruling. The judge decides the stop was not legally justified. Even though the tint turned out to be illegal, the officer didn't have enough reliable basis to stop the vehicle in the first place. That means the evidence could be thrown out entirely. This case shows how important procedure is in the legal system. So, what do you think? Did the judge make the right call, Or should officer experience matter more? If you enjoyed this breakdown, drop your opinion in the comments, like the video, and subscribe for more courtroom content. Fire.